Hearing on House Bill number 497. Representative, please proceed when ready.
Thank you, Senator, for the opportunity to present House Bill 497. This bill is targeted and necessary for reform of the Missouri workers' compensation system, designed to bring clarity and fairness to the process for both employers and employees. I have a background in the insurance industry as an insurance broker, and I understand the oversight level of how these claims function from the perspective of insurers and the businesses. I've seen firsthand how certain legal interpretations have created some imbalances in the system, placing unnecessary financial strain on employees while allowing for claims that extend beyond the original intent of worker compensation laws. At the same time, I recognize the importance of ensuring that injured workers receive the treatment and support they need. This bill strikes a balance in 4 different areas. One, it clarifies the prevailing factor standard to make sure that the worker is represented but not filing claims on pre-existing conditions. 2, it adjusts how insurance savings are considered. If health insurance picks up a part of the tab, we don't want to see a double payment from the workers' compensation claim. It creates 3, it creates an early motion to dismiss mechanism for fundamentally deficient claims, such as untimely filing if an employee was intoxicated or the accident clearly didn't occur during the course of employment. And then 4, it allows for the appeals of temporary awards and eliminates the penalty that can force employers to pay double the damages if they lose the appeal. With that being said, happy to answer any questions.
Questions for the bill sponsor from the committee? Seeing none. First witness in support, please come forward and proceed when ready. And all witnesses, make sure you fill out your witness cards today.
All right. Good morning, committee members and chairman. My name is Justin Reinhardt. I'm an attorney with Vessel Bridges Murphy. I've been practicing law for 10 years, actually as of today. And I focus my practice on Missouri workers' compensation. I'm testifying today in support of House Bill 497 on behalf of the Missouri Auto Dealers Association. There are 4 pillars, if you will, of House Bill 497, ensuring that medical treatment provided under workers' compensation is for work-related injuries by adding language to the law that the prevailing standard factor applies to determinations for medical treatment. The second is regarding collateral source payments and ensuring that there's fair payment of benefits and no double recovery at the employer's expense under the law. The third allows for motions to dismiss to expeditiously resolve cases where certain issues are present. And the fourth removes the penalty for failure to adhere to a temporary award for the employer. Regarding adding the prevailing factor standard to medical treatment, it's useful to note that the workers' compensation law, as it first went into effect back in 1926, was and is often referred to as the grand bargain. Employers accept liability for work-related injuries absent any negligence on their part in exchange for predictability of damages. Now, the law, when it was first passed, as noted by the legislature then, and not too further later on, the Missouri Supreme Court was not deemed to be a, quote, pension, bounty, or gratuity. The theory behind the law was that the loss of earning capacity resulting from injuries in the course of employment was best absorbed by industry who could shift that cost onto consumers. The law was never meant to be, and still is not meant to be, a blanket insurance system. The proposed changes to House Bill 497 to the workers' compensation law further this goal, that it's work injuries that are covered and it's not a general health insurance system. A Western Court of Appeals decision in a case styled Tillotson acted to expand the law into a more general insurance type situation. In that case, a registered nurse had twisted her knee in the course of her employment and suffered a tear of her lateral meniscus. However, she also had a very severe arthritis and degenerative condition in the same knee. Now, 2 different doctors said she needed a total knee replacement, but they said the prevailing factor, what caused the need for that knee replacement, wasn't the workplace accident. It was the pre-existing condition, the degenerative condition, the severe arthritis that she had in her knee. The Division of Workers' Compensation and the Labor and Industrial Relations Commission agreed. But the Western District came in and said that the division had applied the wrong standard. The Western District said that they should have just looked at whether the accident was the prevailing factor in causing the injury, not whether it was also the prevailing factor in needing the total knee replacement. And that decision was based on a strict review of the language of the statute as it is now and as it was at the time in 2011. And that was, it defined injury in part as an injury by accident is compensable only if the accident was the prevailing factor in causing both the resulting medical condition and disability. Again, applying strict review, the court noted that a total knee replacement wasn't a medical condition or a disability, it was a medical treatment. Therefore, the prevailing factor should not have applied to that. This House bill amendment clarifies the law and would then add that prevailing factor analysis to the medical treatment by adding that language to the statute and need for treatment in addition to medical condition and disability. The standard, as it was before, obviously would then lump in non-work-related causes to being covered under the workers' compensation scheme, which it was never intended for in the first place. Regarding changing the collateral source rule at RSMO 287.270, that ensures that there is no double recovery at the employer's expense. So that would cover a situation where, say, the employer's general health insurance plan pays for medical treatment in what would have been an unauthorized claim. The claim is later deemed to be compensable, then the employee then would recover those medical expenses directly and essentially have a double recovery at the employer's expense. So the amendment to 287.20 under House Bill 497 ensures that this will not happen, leads to a more fair result. The addition of 287.445, which allows for motions to dismiss in workers' compensation which aren't presently available, that allows for the early resolution of certain issues. It would greatly improve the efficiency of how the system works. Resolving certain issues at the outset, for example, statute of limitations. If there's a clear statute of limitations issue, a claim is brought beyond the 2 or 3 year period, it's better for that to be handled directly at the outset via a motion to dismiss, as opposed to the costs of several years of litigation, perhaps medical treatment, things like that, only for the case to later be determined to have not have ever gone forward in the first place due to a statute of limitations issue. So the benefits of 287.445 in the efficiency of the system are immense. And then finally, regarding the amendment to 287.510, eliminating the penalty for an employer's noncompliance with a temporary order, that ensures fairness because if the employer disagrees with a temporary order, there's no method for an interlocutory appeal, so they would essentially could have to incur unrecoverable medical costs for an issue to be later overturned at a final hearing on or on appeal after that. So in conclusion, I think all these amendments under the House bill ensure fairness in the system and achieve the original and longstanding goals of the workers' compensation system. Thank you and welcome any questions.
Questions for this witness from the committee? Seeing none, thank you for being here.
Thank you.
First witness in opposition. We'll alternate back and forth between supporting and opposing.
Morning. How are you? All right. How are you? We'll get here.
Mr. Chairman, my name is Mark Moreland, and I'm testifying on behalf of the Missouri Association of Trial Attorneys. I am one of their past presidents. And we oppose this bill for a number of reasons, and I want to speak to the Tillotson issue and also to the issues on the motions to dismiss. We'll have another gentleman, Mr. Ortworth, who's currently on the executive committee, testify then to the remainder of the bill. First, just to let you know, I've done this for 42 years. The first 9 years I did it, I represented employers and insurance carriers. I'm a small business owner. I have a workers' compensation insurance policy. And I'm happy to report, and you can get this off the Department of Labor website, that the cost of having a Missouri's workers' compensation insurance policy has been trending down and has had 4 years of a downward trend, and the prediction, again, on the website is it's going to continue to do so. So there's not some significant issue of cost, driving this. I'm glad the gentleman before me mentioned that workers' compensation was in fact and is in fact a grand bargain. What the employees gave up in 1926 was the right to a trial by jury. So the trade is they cannot go to court, they can't get a jury trial, they can't sue for $5 million and ask a jury to award it to them. Instead, they're confined to the system which restricts their benefits. But one of the benefits that they were to receive immediately is medical care. And so what happens if you alter the Tillotson decision, which interpreted part of the statute that has never been altered as far as I can tell, and certainly not in my 42 plus years of memory of the statute, was 287140. And so simply what the court did is they simply interpreted that statute as written and said that if there's a reasonable relationship between the accident and the need for treatment, then the employer must provide the treatment. That's been the standard in the work comp system for 100 years. It's not some expansion by the court. It has been the standard. So what happened with the 2005 amendments, it's more difficult to prove that the injury occurred at work because work has to be the prevailing factor. Same thing, it's more difficult to prove that an occupational disease is related to work because you have to prove that work is the prevailing factor. But once you establish that you meet that higher burden imposed by the statutory changes of 2005, then the burden for medical care is the reasonable relationship. Now, that reasonable relationship standard just didn't come out of whole cloth in 1926. That's the standard for automobile accidents and slips and falls and other tort claims. If the person that in tort claims was negligent in causing your injury, then they have to pay for things that are reasonably related. So that standard crosses broad lines in our legal system as to how to establish when someone is responsible for payment. Changing this does a couple of things both bad. First, when a person gets hurt at work and they're unable to work, they're receiving temporary total disability benefits. Then and let's say it's Ms. Tillotson and she needs a total knee replacement. I filed a claim and I say, hey, she needs a total knee replacement. All the doctors agree. And they say, no, we don't think you meet the standard. Now my challenge is to have a hardship hearing to get an order for them to provide treatment, which they can then appeal. What's happening to Mrs. Tillotson? She's not working. She's not going to get temporary total disability while they're denying this. So no money, no work, and she's suffering from the pain and discomfort of the injury, which they admitted occurred at work. That's what you do to the employee when you raise the standard. Second, again, one of the things this bill does, which I'm not going to talk about very much, is it eliminates any penalty for the employer's wrongful refusal to pay. Well, what does that do? It incentivizes the employer to deny, and hope maybe that the person goes away or they get it under their group health plan. Of course, that is if they still have a group health plan, because if they can't work, they may get fired. And if they get fired, they may lose their health benefits, because most of us get our health benefits through where we work. So what this does is it fundamentally detracts from what has been agreed upon for a century, which is that when someone gets hurt at work, and now over the last 20 years, and work is the prevailing factor that causes either the injury or occupational disease, then if the treatment is reasonably related to cure and relieve the effects of the injury, the employer should provide it. That is a fair and accurate standard, and has been the standard, as I've said, for a century. The thing that I want to just point out real quick is that every time that I'm down here or hear folks who represent all of us, I hear them talking about our veterans, our first responders, our policemen, our firemen, EMS. These are people that are covered by the workers' compensation statute. So I would submit to you that you're hurting groups of people that you like and that you profess to want to help by changing this standard and making it more difficult. Finally, I would say that all of those hearings to get medical treatment cost money. It requires the employee to obtain a doctor's report, maybe have a doctor's testimony. All that money will come out of an employee's settlement. And so we're reducing the amount of money that the statute would have intended the employee to receive by forcing them to constantly ask for medical treatment under this new standard. Now I want to turn briefly to the motion to dismiss. One of the ideas behind workers' compensation was to make it less expensive to litigate. In circuit court, as you know, you litigate motions, you litigate discovery. Probably most of what you do in terms of litigation is around those issues. Workers' compensation, in its simplified form, has tried to reduce that cost. By creating a motion to dismiss, what you're going to do is you're going to drive costs. You're going to drive the employer's costs because they will be paying their attorney, presumably by the hour, to file a motion to dismiss, to litigate it, to have a hearing, and so forth. If the employee files an appeal, they'll be incurring costs for the appeal practice. You're going to drive costs because you're going to need more administrative law judges. The statute allows you to have 40. I think currently you're in the mid-20s because of retirements, just the governor choosing not to appoint people for whatever reason. You're going to need more of those people. And quite frankly, you're even going to need more space. And the St. Louis office is moving and they're downsizing their space. So you're going to need more space to have hearings. And finally this, and I'll just, again, reference it to circuit court. In circuit court, if someone files a motion to dismiss against me as a plaintiff, they have the burden of proof, and everything has to be construed in my client's favor in order for them to prevail. So every fact that can be construed in my client's favor is, and then they see, is there a motion to dismiss? This standard is harsher on the injured worker, because now we're litigating the issue, and presumably if the employer prevails only by the preponderance of evidence or prevails on establishing certain facts by a preponderance of evidence, they win. So we oppose the dismissal provisions of this. I don't think it provides the help that the employers think it's going to do. I think it burdens the system, it weighs it down. And finally, I would say this. Having done this for a while, if people come into my office and it doesn't appear that they were working for their employer, or it doesn't appear that we have a compensable case or that the statute's run, I don't file it, because there's no point getting their hopes up, spending my time, and then ultimately we lose. And one other thing I'll address briefly is that there was a suggestion, I think, made that you file a claim and then people are doing, the employer's providing medical treatment, and then somehow or another down the road it's like, oh, well, there was a statute issue. I guarantee you, if you file a claim and there's a statute issue, they're not providing medical treatment. They've simply already denied that claim. I mean, so I don't think they're out there spending money on claims that ultimately get denied on what they're stating here, a statute of limitations issue, or other issues such as they've listed. So thank you so much.
Thank you for that testimony. Questions for this witness from the committee? Seeing none, thank you again for being here. We'll now go to the next witness in support. We're not going to limit witness testimony unless we get much more hard up for time than we are right now, but would ask for folks to prevent collateral testimony and to keep your comments as narrowly tailored as possible. Please proceed.
Good morning. My name is Rich Aubuchon. I'm a registered lobbyist for the Missouri Civil Justice Reform Coalition in support of the legislation. The representative's done a great job, and of course the previous witness in support has done a great job in explaining the bill. I can speak from personal experience that the motion to dismiss would in fact be a very good change for this. I don't like doing work comp cases, but I do them for some employers that I have that I represented. And I can certainly say there are times when a motion to dismiss would be useful. And certainly I had one myself that went for 3 years prior to being dismissed for failure to prosecute. And I think that at least addressing the issues that are presented in the bill in a motion to dismiss would be a good change. Also, other pieces in the legislation we believe are also important. Time and time again, we can't just sit back and say that we have addressed these issues, and talking about making changes that would be beneficial for both parties, and certainly with work comp is important to have that discussion. So we look forward to carrying forward that with this legislation.
Questions for this witness? Seeing none. Thank you for that testimony. Next witness in opposition.
Morning. My name is Craig Ortworth. Thank you for the opportunity to speak in opposition to House Bill 497. I'm a member of the Executive Committee of the Missouri Association of Trial Attorneys, and I'll speak narrowly on Section 287-270. It honestly proposes significant changes to our workers' compensation statutes, and I'm certainly not going to read the whole statute, but Part 1 says, any savings from insurance from all government or private sources utilized by the injured employee, any benefits from the employee, or shall be deducted from the compensation otherwise due. The people that have testified in favor of it have called this, I believe, double dipping or getting paid twice. I haven't practiced quite as long as Mark Moreland, but in 25 years of practicing workers' compensation, frankly, that very rarely happens. Instead, what you see is a union employee who is injured on the job and the work comp carrier refuses treatment. That employee must use her own union health provided insurance. And that, as noted in Part 1 of 270, that would be utilized by the injured employee provision. When the case is resolved, that employee must repay, usually in full, her union health plan. Under the current proposed 287-270, the employee would be unable to recover for the medical bills, specifically excluded. However, she would still owe the full union lien. As part of the grand bargain we talked about before, she would not be made whole. They have given up rights that, again, are being restricted here. Another example, I have a client right now who's a municipal employee who was injured on the job. It was an accepted claim. Everybody agreed that he injured his hip. We disagreed, however, on the need for surgery. We were able to ultimately come to an agreement that the surgery was as a result of the work injury, and we came to a settlement. However, the health insurance lien was $30,000. Now, as part of the settlement, the understanding between the employer, that municipality, and the employee, that the union insurance lien, that the health insurance lien would be satisfied. My client did not receive any of that money, did not receive any, as they call, double payment or double dipping. Under this proposal, 287-270, there's a very real possibility that my client's health insurance lien would not have been satisfied or paid because this statute does not give any guidance on what to do with that health insurance lien. Instead, my client would have been stuck paying the full amount. The second part of 287-270 states that if the administrative law judge determines the employer is responsible for the disputed bill, that ALJ shall have the authority to order the employer responsible for the medical bills to order them to make a payment to the medical provider. Again, the provider doesn't provide for the lien, doesn't provide for anybody else. This part of 287-270 gives no guidance on how payments should be made, to whom, or perhaps most importantly, any mechanism for enforcement. In this scenario where there are health insurance liens, union plan liens, Medicare, Medicaid, there is no provision allowing any ALJ to order payment of that lien or to prevent further collection from that injured employee. When we put this all together, I believe that 287-270 does several things. Number one, it incentivizes denying treatment. Employers know they can deny treatment and pass the cause on to the health insurers. Also, it increases the burden on Medicaid with unknown costs to the state of Missouri. At a time that we are constantly worried about funding from the federal government or all sources, we don't need to be putting more stress on that system. And then lastly, it increases the burden on union health plans and employer-based health care with uncalculated costs to the employers and employees. Very few employees, if they have health insurance through their employer, get the full premium paid by the employer. That is part of their bargain that they have with the with the employer. And by now taking away the ability to collect for that, it is in fact not double payment, but double injury. Especially in an area where health insurance, an era where health insurance premiums are skyrocketing, this just injects a large amount of uncertainty into the area. Thank you.
Thank you for that testimony. Any questions for this witness? Seeing none, we will briefly pause here and first establish a quorum. Madam Secretary, please call the roll.
Senators Trent. Here. Gregory. Here. Bernstetter. Carter. Coleman. McCreary. Weber.
All right, we have a quorum. We're also briefly going to go into executive session. So I move that we do go into executive session. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any opposed? Contrary? The ayes appear to have it. The ayes do have it. We are now in executive session. I move first that we bring Senate Bill number 717 before the committee. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any opposed say no. The ayes appear to have it. The ayes do have it. The Senate bill is before the committee. This is the bill that I have sponsored, which would permit court costs and reasonable attorney's fees in cases not involving a public employer under the Missouri Human Rights Act. Any And I move that Senate Bill number 717 be voted do pass. Any discussion? Seeing none, Madam Secretary, please call the roll.
Senators Trent. Aye. Gregory. Aye. Bernstetter. Carter. Coleman. McCreary. Weber.
By your vote of 3 ayes and 2 noes, you have voted do pass Senate Bill 717. I next move that we bring Senate Bill number 559 before the committee. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any opposed, say no. The ayes appear to have it. The ayes do have it. The bill is now before the committee. This is Senator Berger's bill, which would provide government, any entity acting within the scope of a government contract, such as private contractors of a public entity, sovereign or governmental tort immunity to the same extent that the government entity has for purposes of lawsuits. I make a motion that we vote do pass Senate Bill number 559. Do I have a second? We'll have a discussion after this. It's been seconded. Any discussion? Senator, please proceed.
Can you just, one of my challenges with the hearing schedule is I'm double booked. So if you could just remind me a little bit about why private contractors should have. Well,
so essentially, you have situations where private contractors are acting, fulfilling a government contract. In the course of doing so, they are exposed to liability that they have not caused, but in fact the government entity caused, and the injured parties go after them because they do not have any of the protections that the municipality or the government entity has. And so we're essentially trying to level the playing field here, treat similarly situated parties similarly.
Okay, so do they, is this the case in other states too, or is this, because what I'm struggling to see on this one is where it ends. Like if we're giving private contractors with a public, and it seems like it could turn into a snowballing kind of thing.
Well, I mean, that's the nature of legislation. This is confined within, the language that's written on the paper. So there's, what happens in the future is up to future General Assemblies, and it's not within our control. And those future General Assemblies can do any expansion or contraction of these kinds of policies, whether or not we do this. They have it within their power to completely repeal this, alter it, or expand it indefinitely.
Okay. And the witnesses, it looks like it was a lot to do with paving companies and engineering and that kind of thing.
Those were the primary examples of folks that showed up.
So is it mainly transportation related, or does this?
Yeah, a lot of this was in the course of working on highways.
Okay, but the language is that it's written that it would affect any government contract.
Oh, certainly. I mean, there's no reason to limit it to highways just because those are some of the primary examples.
Okay, very good. I thank you for your patience on that. I did not get to hear that testimony, so thank you so much.
Not a problem. Further discussion?
So I do have a question. Want to
Proceed.
talk about it a little bit more. I too share the same concerns. I mean, we basically have, in cases of engineers, I mean, if they're helping design or build infrastructure and something happens, part of their responsibility is to make sure that those structures are safe. So we're giving them immunity just because they have a contract with the government?
So I believe it's more about the nature of the kind of work that they're doing and whether or not the burden of claims is falling in a way that is just. So if you have a government entity that is immune, it takes actions that cause injuries, but it is not liable for damages. And so then a private company who is there performing work in the same vicinity, as many of the people came and testified about, they are held responsible for the actions essentially of the government that they were not responsible for.
But we still are giving immunity to entities who have a contract.
Yes.
And there's not a problem with that. I struggle with. Go ahead. Thanks.
Further discussion? Seeing none, I withdraw my motion that we vote do pass on Senate Bill number 559. We will move to public consideration of Senate Bill number 826. I move that it be brought before the committee. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any opposed to the contrary? The ayes appear to have it. The ayes do have it. The bill is before the committee. I move that we vote do pass Senate Bill 826. Do I have a second? It's been seconded. All those in favor, please, further discussion on the motion that we vote do pass Senate Bill 826. And if everyone will recall, this is Senator Gregory's bill. If he would like to briefly explain it, please proceed.
Yeah, just briefly some of the testimony that was in committee that day. A fine example of that was there's an ag company, had a sprayer, did everything correct, turn signal was on, was turning left onto, say, a gravel road off of a highway. Car hits the sprayer guy did nothing wrong. Gentleman operating the car was totally at fault, but the sprayer operator or ag company was found then to have to pay out money due to lawsuits. There are many other examples of paving companies. Driver fell asleep at the wheel, runs off the road, and they found something very small and minute. And that driver that was at fault for falling asleep at the wheel was then awarded a claim for falling asleep. So this is just looking to clean up how some of that fault is, I guess, addressed in these types of cases.
Further discussion? Seeing none, Madam Secretary, please call the roll.
Senators Trent.
Aye.
Gregory.
Aye.
Bernstetter. Carter. Coleman. McCreary. Weber.
By your vote of 4 aye and 2 no, you have voted do pass Senate Bill number 826. No further business coming before Executive Committee. I move that we exit executive session. It's been seconded. All those in favor, please signify by saying aye. Any opposed to the contrary? The ayes appear to have it. The ayes do have it. We are out of executive session. We will return to our hearing on House Bill number 497. Someone correct me. I believe we had a witness in opposition was the last person that went. I'm seeing head nods. So a witness in support, please come forward. Make sure you fill out your witness card and proceed when ready.
Thank you, Mr. Chairman, members of the committee. For the record, Steve Hobbs. I'm the Executive Director of the Missouri Association of Counties, here to testify today for this legislation. First of all, I want to thank the representative for sponsoring the bill. A little background, Missouri Association of Counties also runs a workers' compensation pool. We insure over 13,000 county employees and elected officials. And this pool provides benefits for our employees as they're injured on the job. And over the years, we've seen a drastic change in our costs. Our goal is to get our employees back to maximum medical improvement, and most importantly, get them back on the job. And I think what the representative is doing here is putting some fairness and common sense back into the statutes where we strayed away over the last few years. Medical costs are just climbing out of the roof, and any small pool like we have is struggles when costs are so high. The jobs our employees do are oftentimes pretty dangerous too. And so we want to make sure that we have the tools to make sure that there is workers' compensation insurance available to our counties. And so I'm here once again to testify in support of this bill. I'll be happy to answer any questions.
Questions for this witness from the committee? Seeing none, thank you for being here. Further witnesses in opposition?
Good morning, Mr. Chairman, members of the committee. Jake Hummel, representing the Missouri AFL-CIO, to go on record in opposition for the reasons previously stated by the first two members from the Trial Association. Happy to take any questions.
Questions for this witness? Seeing none.
Thank you.
Thank you. Further witnesses in support?
Chair Trent, members of the committee, my name is Luke Reed, and I'm here on behalf of the Missouri Chamber of Commerce and Industry, here to voice our support for House Bill 497 for the reasons aforementioned. You happy to take any questions?
Questions for this witness? Seeing none. Next witness in opposition? Seeing none. Next witness in support?
Good morning. Matthew Smith with Associated Industries in Missouri. Just want to go on record in support of this bill.
Questions for this witness? Seeing none. Next witness in support?
Good morning, Mr. Chairman. Hampton Williams from the Missouri Insurance Coalition, testifying in support of this bill, particularly the motion to dismiss portions as well as the collateral source language. Happy to take any questions.
Questions for this witness from the committee? Seeing none. Further witnesses in support?
Mr. Chairman, members of the committee, my name is Dan Shaw. I'm here on behalf of the Missouri grocers, Missouri retailers, and I'd like to offer my support for this bill as well.
Questions for this witness? Seeing none. Next witness in support? Seeing no witnesses, further witnesses in support. Any witnesses for opposition? Seeing no witnesses in opposition. Any witnesses for informational purposes only? Seeing none. Representative, do you have any final remarks?
Thank you for the time today.
Thank you, Representative. That will conclude the public hearing on House Bill number 497. We will next proceed. We will next proceed to public hearing for Senate Bill number 584. Senator, please proceed when ready.
I guess everyone walking out doesn't like American beer, since that's what I'm presenting before you today. Mr. Chair, members of the committee that are still with us, Senate Bill 584 is going to be known as the American Beer Act. I think this is great legislation to reward those American brewers that have decided to invest in Missouri jobs and Missouri workforce and the American workforce, American farmers, the Missouri farmers, and our economies and our communities. Let me start off by saying what this would do is currently the excise tax is 6 cents per gallon on a gallon of beer in the state of Missouri. This is going to lower it down to 2 cents per gallon. The necessity of this is in Missouri is paramount to the future of the beer industry in the state and across the United States. America's beer production is continually shifting to Mexico at an alarming rate. And why is that? That's because they have lower labor standards, cheaper inputs, et cetera, et cetera. The list goes on. over the last 20 years, growing from 11% of imports to 24%. Of those imported beers, 80% have originated in Mexico, as I mentioned, where it's cheaper to produce. All this comes at the expense of American workers, farmers, and communities. If all the beer that was produced in Mexico that's moved down there came back to the United States, it would add 22,000 jobs, nearly $1 billion in taxes, and over $15 billion to the United States GDP. You might wonder, why is this important to the American farming economy? And just brands that are brewed in the state of Missouri, Anheuser-Busch, Budweiser, Bud Light, rice. We've got rice farmers down the Boot Heel. Busch Light, one of my personal favorites, happens to come from corn. One of my favorite cans is the corn can, obviously. They had at one time the bushel pack where there was 56 cans, because 56 pounds of corn equals 1 bushel, so they called it the bushel pack. Genius marketing, in my opinion. And then last but not least, if anyone's ever heard of Boulevard Brewing Company in Kansas City, one of their best brews is the wheat, Boulevard wheat. At one point in time, and I still think it does, almost all that wheat comes out of Saline County, which is the county I represent. Actually, the seed company I worked for, we grew and cleaned and bagged and then shipped that wheat up to Kansas City. So this wouldn't apply just to the big guys. It would also apply to craft brews located all across the state. As I mentioned, Kansas City, you've got KC Beer Company and Boulevard, Columbia, Logboat, Springfield, Mothers, and also in St. Louis, you've got Schlafly. And so obviously defined American beer brewers that have facilities located inside the United States. So I think this is good for pretty much everybody involved, and look to be a leader in putting these American brands first.
Thank you for that presentation. Any questions for the bill sponsor from the committee? No one can say these hearings aren't informational. First person in support.
Good morning, Mr. Chairman, and thank you to the committee. My name is Adam Kazda, Director of State Government Affairs for Anheuser-Busch. Anheuser-Busch would like to publicly go on record in support of Senator Gregory's 584. Anheuser-Busch has called Missouri home since 1857. Our 3,000 employees across 9 facilities in Missouri help to make and distribute America's iconic beers every day. We're proud to be a leading contributor of the state's economy and a committed community partner. Our family of independent Anheuser-Busch distributors also significantly contribute to the state's economy. Across 16 independent beer wholesalers who distribute AB products, an additional 1,200 workers are employed, and our distributors add hundreds of millions we pay in state and local taxes, supplies and services purchased, and capital investments in this state. The change in Missouri's excise tax for American-made beer is a small but significant change for the American beer industry. As the Senator mentioned, America's beer production is shifting to Mexico at a rapid rate and with alarming consequences for our economy and our communities. By forcing American brewers to pay the same rate of excise tax in Missouri as imports, we are effectively giving an advantage to foreign beer, mainly at the expense of American workers, farmers, and communities. The pride we take in this great country should be properly and accurately applied to the American beer industry. As our CEO, Brendan Whitworth, recently wrote in a letter to our U.S. wholesale partners that encouraged them to work together to change industry terminology from domestic to American when describing beer made in America, American beers are the products of American hands. They are brewed by American workers who receive American wages. They rely on American farmers and on American raw material suppliers. They support American causes like military and first responders. They pay American taxes. And they exist because of decades of capital investments made in hundreds of local communities right here in Missouri and across this great country. Sometimes that capital is even used to help American communities when they need it most, like donating 50,000 cans of emergency drinking water to support Southeast Missouri residents recovering after tornado damage and extreme flooding. Like other American brewers, 99% of the beer that Anheuser-Busch sells in the U.S. is made in the U.S., and 99% of our ingredients come from American farmers. For these reasons, we're proud to voice our strong support for SB584 and thank the sponsor for his vision and partnership. If signed into law, this initiative would show American brewers in this state and across the U.S. that Missouri stands with American workers, American farmers, and American communities. We encourage the community to give this bill favorable consideration. Thank you.
Thank you for that testimony. Questions for this witness? Seeing none. Thank you again for being here. Further witnesses in support?
Mr. Chairman, members of the committee, my name is David Overfelt, and I am the president of the Missouri Retailers Association, and very briefly, we support incentivizing the production of American-made beer and, of course, Senate Bill 584.
Thank you for that testimony. Any questions for this witness? Seeing none. Further witnesses in support?
Mr. Chairman and members of the committee, my name is Sherry Wolgemuth. I represent the Missouri Craft Brewers Guild. We have over 165 American craft breweries operating in the Show Me State right now. We employ about 8,500 individuals, and we're in communities all over the state, and we are absolutely in support of this bill. Thank you.
Thank you for that testimony. Any questions for this witness? Seeing none. Further witnesses in support?
Chair Trent, members of the committee, my name is Luke Reed, here on behalf of the Missouri Chamber of Commerce and Industry. Once again, proud American and proud supporter of this legislation because beer is such a huge part of Missouri's economy, and we are very proud to stand alongside all of our members in support of this.
Thank you for that testimony. Questions for this witness? Seeing none. Further witnesses in support?
Mr. Chairman, good morning. My name is Ronald Leone. I'm the Executive Director for the Missouri Petroleum and Convenience Association, so I represent many of the gas station, convenience stores, and truck stops in your districts. I really don't have much to add to the testimony that's been given previously. We just want to go on record in support of the bill. We support the bill because we support American-made products. Happy to answer any questions.
Questions for this witness? Seeing none. Thank you for being here. Further witnesses in support?
Good morning, Camelia Peterson with Americans for Prosperity, and we are always fans of reducing tax burden and especially fans of local breweries as well. So thank you for the shout out to Mother's Brewery. They have my favorite coffee stout. So anyway, thank you.
Thank you for that testimony. Questions for this witness? Seeing none. Further witnesses in support?
Good morning. Matthew Smith with Associated Industries in Missouri. Just want to go on record in support of this bill. Provides a competitive edge to local and American companies and supports beer companies in Missouri, both large and small. And Coffee Stout is also a very good beer.
Thank you for that testimony. It met with audience approval as well. For any questions for this witness? Seeing none. Further witnesses in support?
Chairman, members of the committee, Dan Scholl with Missouri Grocers Association. We're in support of this bill. Please stop by our stores anytime, pick up whatever you want, this and anything else. Thank you very much.
Thank you for that testimony. Questions for this witness? Seeing none. Further witnesses in support?
Thank you, Mr. Chairman. Jay Cummel from Missouri AFL-CIO. I have always wanted to testify on a bill with AFP, the Chamber of Commerce, Associated Industries. We are just lockstep in support of this legislation. But in all seriousness, my folks build the facilities, we operate the facilities, and we distribute the product, and we're happy to help any kind of American manufacturing in the state succeed.
Thank you for that testimony. Questions for this witness? Seeing one, please proceed.
I wish you, good morning. I wish you'd looked at your cell phone before you came up here. I was hoping you were going to talk about your beer belly.
I know my wife told you to say that, didn't she?
No. Just came up with it on my own. Thank you.
I refuse to answer any more questions. Thank you, Mr.
Any further questions for this witness? Seeing none. Other witnesses in support?
Mr. Chairman, Scott Ramshaw with the Plumbers and Pipe Fitters out of St. Louis, Missouri. Anheuser-Busch has been a true partner with our organization. We've had contracts going back over 100 years. We stand with Anheuser-Busch and throughout their facilities throughout the United States. And, we're proud of the fact that we help deliver the best beer in the country that runs through our pipes. And that's done through the brewing process, which many of the processing systems that it takes, steam, condensate, caustic systems, we install those, and we're proud to support this bill, Senate Bill 584.
Thank you for that testimony. Questions for this witness? Seeing none. Next witness in support? Seeing none. Witnesses in opposition? Seeing none. Witnesses for informational purposes only? Seeing none, that will conclude the public hearing on Senate Bill number 584. Senator, do you have any closing remarks?
Thank you for considering this.
Thank you, Senator. We will next proceed to public hearing for for House bills number 145 and 59. Please proceed when ready.
Thank you, Mr. Chair, members of the committee. My name is Bill Falkner, District 10. House Bill 145 and 59 is a protection. The underlying bill is protecting students' private information 17 and under that participate in municipality events, whether it be Student Government Day or Summer Jam basketball. Right now, we cannot protect that information. Someone can sunshine that information. We're trying to protect that. Also added in this bill was the keeping the state parks from people being able to sunshine request those in case people are out of town, to kind of protect that information. This was added last year when it came through the Senate, and so we put it on here as well. There's also a portion in this that protects the specific locations of plant or animal species considered endangered, so someone couldn't get on sunshine their request, unlike the black bear, how they move around. So you could request that information, I guess, go hunt the black bear. So that was added. And also, there's a portion in here that protects the information on sewer bills in the St. Louis area. So I guess they were having problems there, so we're trying to correct this as well. I will say that we have worked with the Press Association very closely on this bill to make sure that we were working together. So with that, I'll take any questions.
Questions for the bill sponsor from the committee? Seeing none, thank you for that presentation. First witness in support.
Good morning, Mr. Chairman, members of the committee. My name is Richard Sheets. I'm the Executive Director of the Missouri Municipal League, and we'd like to go on record to support House Bill 145 and 59. We've worked with the sponsor, Representative Falkner, on this for a number of years. It's really important. Many of our cities sponsor programs, recreational programs, other activities where minors are involved. And it came to our attention that those records aren't closed, like in other areas in schools and those. And this bill just simply protects the records of those minors from predators and also, being solicited from commercial entities in their recreational activities. I'll try to answer any questions if I can.
Questions for this witness? Seeing none. Thank you for being here. Next witness in support.
Thank you, Mr. Chairman and members of the committee. My name is Shannon Hawk, and I'm here today on behalf of the Municipal League of Metro St. Louis. This issue first came to us, it was brought to us by a mayor in St. Louis County who actually started receiving these types of sunshine requests that were very specific to children. It could be for, a summer camp or swimming lessons or something like that. It could also be, we have a lot of cities that have like youth and government type groups, and so kids participating in that, or just young minors that are working a summer job for the city. Any of that information is available. We have this language also on another bill that deals with human trafficking, and it became a very important component of that bill because this is just another way to help protect children. I've also been approached by folks that have said that, maybe in a dissolution of marriage, something like that, where someone does not want their children's information to be out, or in a domestic violence situation. So this is just one way that we're trying to work to help to protect that personally identifiable information of minors. Thank you.
Questions for this witness from the committee? Seeing none. Thank you for being here. Next witness in support.
Mr. Chair, members of the committee, my name is Kaina Iman. On behalf of the Missouri Park and Recreation Association, we like the underlying bill that Representative Falkner just presented, and Mr. Sheets and Ms. Fuller. And we also support the section relating to state parks that was added in the conservation section from the Conservation Federation of Missouri. And also the Metropolitan St. Louis Sewer District is closing a section of record, or just clarifying that it is a utility that is created under the Constitution in that article. So if you're wondering what that language is, that's for MSD.
All right, thank you for that testimony. Questions for this witness? Seeing none. Further witnesses in support?
Good morning. My name is Doug Cruz with the Missouri Press Association. We are in support of the bill. We've worked with legislators in the House on all parts of the bill. We would like to see a change regarding that allow the public to know where campers are coming from, but not their names or residential addresses, but their cities, zip codes, that kind of thing. We've discussed this with legislators, and I think they agree with us. They would support that. So that's our testimony.
Thank you for that testimony. Questions for this witness? Seeing none. Further witnesses in support? Seeing none. Any witnesses in opposition? Seeing none. Any witnesses here for informational purposes only? Seeing none. Representative, do you have any final remarks?
Thank you for hearing the bill, and we are fine correcting that language as the Press Association said. Thank you very much.
Thank you, Representative. That will conclude the public hearing on House Bill number 145 and 59, and we will next proceed to public hearing for House Bill number 147. Representative, you were obscured in the back there. I wasn't sure if you were here, so please proceed when ready.
Mr. Chairman, members of the committee, thank you. Representative Barry Hovis, District 146, Southeast Missouri. I was obscured. I'm surprised that the beer people left, because when you're in retirement and drinking beer, that sometimes goes together, but I'll try to get through the retirement bills here. House Bill 147 that I bring before you was one that we heard on the House floor. It was voted out 140-1. It also includes several other bills, and I'll try to go through them quickly to maintain some time here. But House Bill 147 dealt with the St. Louis Police Retirement System. There was an issue that popped up several years ago. Didn't happen often, but there were some lawsuits. Basically what happened, someone had sued. They received a payment, and they wanted that payment to be used in the calculation of their final retirement. But the problem with that particular system, or what they wanted to do is that created a liability for the system, because even though they wanted that to be calculated into their final average salary upon retirement, there had been no money put into that. This fixes that. There was a change in policy by the board saying that if they wanted to use that final settlement, to calculate out their benefit, that there would have to be an actuarial assessment made, and that money would need to be paid out of that to make the system whole so that it would not place them at a liability. That came out of the House Committee 16-0, and everyone agreed with that. And the second part of this particular House Bill 146 deals with a fix for the locker system, and I can go through them pretty quickly here, but one of them deals with being able to vest with the system on a year's calculation. That was a fix. Another one changes, it sets it for CPI index versus the one that used to be there, which was urban wage earners and clerical workers. Those, we went back and looked at those, very little difference over the years in those, so we set the CPI for that at their request. A couple of other things that was on the loggers fix there. Was dealing with Investment Securities and Exchange Commission. There are people that did investment advice, or not investment advice, but counseling to the members of the logger system, local government system, had to be certified. They found that was probably not needed for most of the workers they have there. So we changed that so that would allow them to do the training in-house and save some money for the particular system there. The next bill that we had in here, which was brought by Representative Hinman, dealt with the, make sure I got this right here, the St. Louis Firefighters Retirement System. As you well know, in the city of St. Louis, there's now two systems, one run by the Firemen's Board there, which has been around forever, and then one that was established by the city a few years ago, which was managed by them. They both deal with firefighters and their retirement. They've decided, and there's an agreement between the Board of Aldermen and the Firefighters Association that runs the first system there, to merge that into one group to save money. And there are safeguards that have been in place there now for them. If they have a disagreement or something pops up, they can deal with. The next thing that we have on here deals with Representative Owen's bill, and this is proxy voting and fiduciary investment duties for certain public employment retirement systems. And this deals with, you know, probably one of the issues that sometimes we find controversial, but if someone in a retirement board would want to make a decision on investments based on it not being the best investment decision, does it make money, does it lose money, but based on other things that they may want to use, we've heard it called many different things, DEIs, things along those lines, that they have to make it based on whatever the best decision for that board is based on the monetary value part. And it just sets some directions on that. The other bill that's in here, which was brought to me by our treasurer of the state, Vivek Malik, was House Bill 977. This is a committee substitute, basically, that was able to get support from the industry that they said could be workable. It matches most of the policies that we already have in place, but it deals with any investments in foreign adversaries that meet any of the government list, whether it be the OFAC list, which is the Office of Foreign Assets Control, Department of Treasury, Department of Defense, where they place a country or an entity or some group on a no-invest list because they are basically adversaries of our country. And this puts some guidelines in place on that. It came out of committee 13-1 with 2 present. We also have a private pension taxation bill here that was brought forth by Representative McGurl. This deals with private pension investments, and it allows for certain, I guess, deductions to occur on your taxes when you make those investments. He wanted to bring that up to the standard. There had already been some changes made on the public side. This helps the people that invest privately for their own retirement. This one was voted off of the House floor 147-1. And him being a CPA, if you have any in-depth questions on that, I'm going to have to probably refer you guys to him privately. He'll come see you. But that deals with that particular part of it. And I think the last one we have on here was the St. Louis teacher retirement system. Several years ago, this body enacted some changes there to reduce that overall amount that was paid in by the school board or the city, I guess. And then basically what's happened is that forced deduction has placed them below what is needed to maintain the integrity of that system. And so what this bill does is a fix that was brought forth by several members over there that would allow the board to raise that fee and cap it at 14%, which would allow them to start increasing it again to be able to meet those actuarial assessments that are needed to maintain the integrity of that system. And I hope I've covered all of them and can take any questions that the committee may have.
Questions from the committee for the bill sponsor. Proceed.
Representative, first up, thank you for your work on this. Pensions are crazy complicated. I know if you pull one string here, you've just moved like $7 billion somewhere else.
Yes.
And it's also just an issue that everybody, the people that it matters to, if you're in that pension system, it's like the whole world. So I sincerely mean that in terms of, I really appreciate you putting all this work in this. I am a little bit confused just that I was hearing you say that it's important to make the best investment decision no matter what. And then I think I checked my phone or I got a text or something, and I checked out for a second. When I locked back in, you were listing lists of places that people couldn't invest because that was bad if they invested there. Because do you understand those come across, at least to me, as
Could be conflicting, I understand.
I mean, I would say opposites is probably the right word. Like they're two opposite things.
So the example that we used, maybe from one of the witnesses that I had heard, was if we talk about the bill that deals with not investing because of personal feelings and not for the best interest of the pension system, we want to make sure, an example is given with me. Let's just say you have a board and they're getting ready to make a decision on an investment, and let's just say it deals with an oil company. Well, they say, I think, one of the board members would say, well, I think oil's terrible. We should never invest in that. It pollutes this, it does this, everything along those lines. And then they would say, we're not going to invest in that company, even though they're getting 15% returns a year for the last 5 years. And so you'd want to, and that, I'm just using that as an example. It may not be that much, but you would not want to have them making a decision based on a personal feeling of they don't like a certain entity or a certain company or a certain whatever, and they would do that not in the best interest, because pension systems truly are in the business to try to make money to make sure that they meet the obligations that they owe to that particular retiree as they reach that time. The other one is, and this was a separate bill, this would have been the Treasurer's bill, where you have a country or an entity that is an enemy of our state, and we've got several of them that's been identified. And yeah, they may still be someone that would make money in what they're doing, but are they doing it at the direction of trying to take over our country, defeat our country, or to make us weaker so that we cannot stand up and bring the freedoms that the United States offers to the world? And so if you'd have a country, and I could probably name a couple off, we tried to avoid that. I know China was listed in this particular bill.
Like Canada, I know.
Yeah, and so, but
you didn't even know you didn't like Canada until 6 weeks ago, and now you don't.
Yeah, well, yeah, there's a lot of discussion going on with all that, I understand. So, but I think that was probably the intent of those two separate bills there, that if we've got a hard and fast list where we don't invest with them because they are doing it for, and I can tell you stuff from being in law enforcement, I still know people that work in various government agencies, even at the federal level, and, even with, I'll use China as an example because this is something they truly know to be true, is that many of the students that come over here actually want to get a great education. Their parents want them to be able to get stuff they may not be afforded in the country that they're at. But he told me that from the stuff that they've worked on for the last 20 years, that typically 5 to 10% of those students come over here are actually spies. They're selected by their government to come here and to infiltrate, get an education like any other student, then find a way to actually get invited to go work in a company as, just trying to learn a trade there. And they're either going to, if it's not military secrets they're trying to take back, they're maybe trying to take back just production secrets so they can recreate that in our country and basically compete us and throw us in a bad spot.
So again, I appreciate your work on this. My suggestion, just for whatever it's worth, is that maybe we should, before we bring it to the floor and it dies, we should pick a direction, whether we think this is a good idea to regulate what people invest or whether we think it's a bad idea. Because right now what you're saying is if you individual senators don't like it, then too bad, we're doing it anyway. If we individual senators don't like it, then we're banning it.
No,
I mean, that's what the bill says. So I would just suggest that maybe pick a direction, maybe pick a cohesive philosophy or cohesive theory of how you want this to proceed, and then let's go down whichever path that is, rather than trying to see a fork in the road and say, screw it, we're going to drive straight through the center of that fork. And that's, I think, what this bill currently does. So just my suggestion, just to save everybody time, is let's pick a direction before we
I appreciate that, and we didn't have hardly any people opposed to it on the House side, but I understand if there's concerns over here, be happy to work through those with
I appreciate it. Thank you.
Further questions? Seeing none. First witness in support.
Good morning, Barry. Good afternoon, Mr. Chairman and members of the committee. My name is John Barget. I am here appearing on behalf of the St. Louis Police Retirement System in support of the original tiny little bill that the gentleman introduced. I am pleased to tell you, as Representative Hovis mentioned, this is a bill dealing with the St. Louis Police Retirement System, and it may be the only thing you ever hear about the St. Louis Police that the mayor, the Police Retirement, and the Police Officers Association are all in support of. So with that, I'm happy to answer any questions on that little piece of the bill, and thank the gentleman for introducing it and for you giving it a hearing, sir.
Thank you for that testimony. Any questions for this witness? Seeing none.
Thank you.
Further witnesses in support?
Good morning, Mr. Chair, committee members. My name is John Brewer. I'm the Executive Director of the Firemen's Retirement System of St. Louis. Speaking in favor of the bill, particularly Chapter 87 portion, it brings both systems into one administration, one board. That's good for the firefighters, it's good for our administrative staff, and it saves the city of St. Louis money as well.
Thank you for that testimony. Questions for this witness? Seeing none. Further witnesses in support?
Good afternoon, Mr. Chairman, members of the committee. My name is Demetrius Alfred. I'm the president of Missouri State Council of Firefighters, also a retired member of St. Louis Fire Department. I'd like to speak in favor of this House bill and thank the sponsor for all the work he's done. We've been working with him for quite a while. He's dug in deep, and we appreciate everything he's done for us. So we're in support of the bill. Thank you.
Thank you for that testimony. Questions for this witness? Seeing none. Further witnesses in support?
Good morning, Mr. Chairman, members of the committee. For the record, James Harris representing FGA Action, here to testify in support of House Bill 147, specifically Bill Owen's amendment that was on pages 17 and 18, dealing with investments on fiduciary responsibilities. We think it's a good thing just to kind of keep the eye on the ball of what investments are about, and then why it matters is if these funds have problems, ultimately people probably come seeking help elsewhere. I think the senator had a very good point on maybe the two parts needing to have a discussion since they might conflict with each other. Happy to answer any questions.
Questions for this witness? Seeing none. Further witnesses in support?
Mr. Chair, members of the committee, for the record, Elizabeth Altoff with the Local Government Employees Retirement System. Just want to be on the record in support of the provisions in this bill specifically relating to our system. So that would be for reference to the Chapter 70 changes. The 8 technical cleanup provisions, they don't materially change anything in terms of the administration of our plan. So we are in support of those. Happy to take any questions.
Questions for this witness? Seeing none. Thank you for being here. Further witnesses in support?
Good afternoon, Chairman Trent, members of the committee. Maddie Green, on behalf of the St. Louis Public School Retirement System, we just want to go on record in support of this legislation. Thanks.
Questions for this witness? Seeing none. Further witnesses in support? Seeing none. Any witnesses here to testify in opposition? Seeing none. Any witnesses here to testify for informational purposes only?
Yes, Mr. Chairman, James Harris again for State Armor Action, here to testify. Just for information, we'd like to work with the bill sponsor, maybe the committee, on some changes to his House Bill, was that 997, on the kind of divestment pieces from China. Because what we've seen, and it was actually on Fox Business this morning. I know I say that, some people go, "Why do you listen to it?" But on basically an omission from the original part of the bill that came out in committee that kind of says, more look at OFAC and other federal registries. The problem about that is, and it was in a U.S. congressional hearing yesterday, is many of these Chinese companies that are on the naughty list, Department of Defense, Commerce, etc., are creating subsidiaries to get into funds to access the U.S. capital markets because they need the money. And he even said that there needs to be action. So I think the original bill would kind of accomplish that purpose, but again, it needs to be part of a larger discussion on stuff. Happy to answer any questions.
Questions for this witness? Seeing none. Further witnesses to testify for informational purposes?
Good morning, committee. Abby Spieler, Executive Director, Missouri State Employees Retirement System. Just want to go on the record that the provisions in 105 that do apply to Mosers are no impact to the system currently. We'll continue to work with the bill sponsor as well. Thanks.
Questions for this witness? Seeing none. further witnesses to testify for informational purposes? Seeing none, Representative, do you have any final remarks?
I'd like to thank the committee for hearing this bill. There's not a lot of shots at fixing pension stuff. It's not one of the rising stars typically, but that's why we put a lot of them together, get them over here for your consideration. I appreciate that time. Thank you.
Yes, very important. Thank you, Representative. That will conclude the public hearing on House Bill number 147. With no further business coming before the committee, I move that we stand adjourned. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any opposed to the contrary? The ayes appear to have it. The ayes do have it. The committee is adjourned.